omnibus law is, hang on, that's a screen, okay. There are also more material challenges to the omnibus law. I believe in total 16 or so. So they will all have to be dealt with before the omnibus law actually becomes effective. But to give you a short and fast answer, I don't think there is a relation between the Apostille Convention and the omnibus law.
Thank you.
And the final is from Sally Rahmadinda Mantolas. My question, what is the relation amongst the apostille and the economic transaction? Is it have a relation with the investors too? Good question, and I'm glad you raise it because this is often a misunderstanding. The apostille convention will only certify that a document has been validly executed, has been validly signed. We'll get to that later, but I can already tell you now, an apostille does not make a document more valid as far as its content, as far as what's in it, than without an apostille. It is mainly a tool for the recipient of that document to ensure that the person who is stated to have signed it has actually signed it. So the answer to your question is negative. There is no relation among the apostille and the economic transaction. And does it have a relation with the investors? No, other than if the investor or the other party to the economic transaction receives it, he or she knows that it cannot be invalid based on its procedure of execution. So it basically means that if I receive a document with an apostille, I know that it was validly signed. I don't know whether the content is valid, and I don't know whether the person who signed it was actually competent. Did he have the right approvals? I don't know that. The only thing that the apostille tells me that it was executed by a person in the name that is on the document. Going down, Cynthia Satvika with a question. The Apostille Convention greatly simplifies the public authentication of documents to be used abroad. But is the legality guaranteed? Well, just the question I just dealt with, and a good question. The legality is not guaranteed. It depends, however, on your definition of legality. If you say, was it formally executed by the person stated as an executor? Yes, you have that certainty. Is it legal in terms of, is it enforceable against the other side? Is it valid under the laws by which it expressed to be governed? No, you don't know. The apostille question does not deal with that type of legality. Second question from Sally. What should be done in doing infrastructure? As we know, Indonesia is still new and will implement the Apostille Convention soon. Well, if you mean with infrastructure of the regulation, I have already said we need implementing regulations. If you mean infrastructure in another meaning, I'm not sure that what the answer would be. Okay, we'll do one more question, because otherwise my presentation gets delayed. Your question, what are the advantages and disadvantages of this discussion? Well, that's up to you. I don't know what the advantages and disadvantages of the discussion is. I think it's useful, but you may disagree. Okay, I'm going to stop here now. That means that those who have questions that I haven't dealt with will be able to put the question to me in the next session in about 20 minutes or at the end. So I'll go back to my speech now. We were at the discussion, what are public documents? And I've listed here the four that the convention mentions, which is documents emanating from an authority or official connected with the courts, including those emanating from a public prosecutor, administrative documents, notarial acts, and official certificates attached to documents signed by persons in their private capacity, such as an official certificate that records the registration of a document or the fact that it was in existence on a certain date, and the official and notarial authentication of the signatures it contains. Now, interestingly, Indonesia and the convention allows to make reservations, and Indonesia did that with one exclusion of documents, namely those issued by the office of the prosecutor or the Attorney General's office. Those documents cannot be authenticated through an apostille. I'm not sure I know the exact background of this. It may have something to do with the political sensitivity of extradition treaties or similar sensitivities, but this shows that Indonesia didn't want those documents to go through the fast lane route of the apostille. Next question, please. Sorry, next slide. Okay. I'm going to spend some time now on those four public documents. The four categories of public documents listed in Article 1. It's not possible to establish a complete list of all public documents that may be executed in contracting states, or to list all the officials or authorities which may execute public documents in those states. The purpose of the list is to ensure that these categories that are in the list are treated as public documents. But the list is not exhaustive. It need not necessarily be complete. Therefore, the convention applies to a document that is considered to be a public document. And who determines that? The law of the state of origin. Even though it doesn't fall within the one of the categories that I've just mentioned and that you see on the screen now. In practice, most documents that are apostilled under the convention do, however, fall within one of the listed categories. The range of documents falling within each listed category is also determined by the state of origin. I've said that before. Therefore, this range may vary among contracting states. One state may call a document public, the other one may not. It makes no difference to the applicability of the convention whether the document falls within category A, B, C, or D, or indeed whether it falls in any of these categories. What matters is that the document is a public document under the law of the state of origin. Okay. An administrative document, and that's category number 2, is a document that is issued by an administrative authority. Now, whether a person or a body is an administrative authority is to be determined again by the law of the state of origin, noting that in some states this may include religious authorities. While differences will therefore exist among states, administrative documents will typically include the following: birth, death, and marriage certificates, as well as certificates of non-impediment, extracts from official registers, for instance, company registers, property registers, intellectual property registers, population registers. A third category would be grants of patent or other intellectual property rights, grants of a license, medical certificates, health certificates, criminal and police records, and educational documents. Now, according to Article 13b of the Convention, administrative documents dealing directly with commercial or customs operations are excluded from the scope of application. Okay, one of the most important categories of public documents is the notarial acts. The third one I mentioned, the third one that's also in my paper. Notaries are found in virtually all countries of the world. They play very important public functions, including in Indonesia. A notaris is a very important function, plays a crucial role in business. In almost every civil law and mixed law jurisdiction, and generally throughout the common law world, notaries are legal professionals. In some common law jurisdiction, notaries, and there they are called notaries public, typically are not required to be legal professionals, but instead are ministerial officers with limited powers and functions. Notaries make notarial acts, and those would be instruments or certificates drawn up by a notary that sets out or perfects a legal obligation or formally records or verifies a fact or something that has been said, done, or agreed. When authenticated by the signature and official seal of the notarial act has become a public document. In those jurisdictions where the term notarial act does not refer to an instrument or certificate drawn up by a notary, but rather to a function that the notary public is authorized to perform, such as taking an acknowledgement or administering an oath, documents certifying the performance of that function would not fall under the convention. Instead, they would fall under Article 1.2d. So they would fall under the convention, but not under notarial deeds, but under other documents. Okay. Let me stop that here and go to the next point. We get to another crucial subject in the convention, which is the competent authority. Under the convention, each contracting state must designate an authority that is competent to issue apostilles in that state. Somebody must issue those apostilles. You can't just sign them yourself. It must be an official authority that does that. Now, what does the competent authority do? It verifies the authenticity of the public document, if necessary by following up with officials and authorities or through its own database. It then issues the apostille by filling in the apostille stamp and attaching it to the underlying document. It records the apostille in its own register, and then later on, it may verify the original of apostilles if a recipient doesn't understand or doesn't trust it. Then that recipient can go back to the competent authority that issues the apostille and say, by the way, is it really issued by you? And the competent authority will then say, yes, it was issued on that and that date and on that and that number. Or it will say, no, it must be a fake because we don't know it. Now, interestingly, the Hague Convention, the HCCH website, has already listed the Ministry of Law and Human Rights in Indonesia as the competent authority for apostilles in Indonesia. My Indonesian colleagues tell me that no formal regulation has been issued on this matter, and that in reality such a regulation is necessary. So whether that HCCH information is completely correct, we don't know. However, ever since the convention was adhered to and was adopted by Indonesia, speculation has been that it would be the Ministry of Law and Human Rights. So if it is the Ministry of Law and Human Rights, nobody will be surprised. Next slide, please. Okay, now I wanted to give you some day-to-day practical experience that I have had, because that hopefully makes all this stuff that I've been telling you a little bit more realistic. I will actually show you a couple of documents that are used. And don't forget, I'm talking about the old system. The new system is not yet in place. But I've taken the Netherlands because I'm a Dutch citizen, and I require for my work permit every year to go through the route of legalization of certain documents. The Netherlands has already been a member of the Apostille Convention, I think from the start, but at least from the very early part of it. And why did the Netherlands think it's important to do that? Because international trade, the Netherlands is a very small country. Its economy is for a large extent dependent on international trade and international finance. Now, all those agreements must be ensured to be valid and enforced and validly executed. And the apostille shows that the signature on the document is genuine. With an apostille, it can be used for Dutch documents in any country that is a member of the Apostille Convention. And in the Netherlands, one can apply for an apostille from the competent authority. In Holland, that is not the Ministry of Law, it is the Dutch District Court. We have in Holland a large number of district courts, not as many as Indonesia, but in the last time I counted, there were 18. But I must say that because of economizing measures, many district courts are now merged, and there are definitely quite a few less than there used to be. The application procedure is not the same in every court. So if you go to the Court of Amsterdam, you may find a different procedure from that in the Court of Rotterdam. But you can choose. And some courts are known to be more efficient than others. So that is, and I should also add that the Dutch procedures for court apostilling are very informal. You can just go to the counter, show your document and say, can I have an apostille? Often it is finished, it's done in the same day, or it is done the next day. And let me think ahead. Of course, with the e-apostille, once that's completely implemented by many countries, it's a matter of pushing a button. And the whole process will be extremely simple. Okay, let's go back to the Netherlands. Next slide, please. Okay, well, I've said most of this before. So I'll just leave you to look at this. Important thing to note is that there are, if the Apostille Convention does not apply, there are 5 steps. The first one is the statement. And let's take the example of a declaration of good behavior, like I have to give to the Indonesian authorities every year. That must be signed by the authority, and I'll show you an example later. The signature of that authority must be certified as true by a notary. The signature of the notary is authenticated by the district court or official. Sorry, the district court official. Then that signature of the district court official must be legalized by the Minister of Foreign Affairs. And then the signature of the Minister of Foreign Affairs representative is legalized by the Indonesian embassy. Can you imagine how much time that takes? How much unnecessary money and time that takes? And wouldn't it be much easier if this 5-stage, cumbersome and time-consuming process was replaced by one where there's only 1 step or 2 steps? The answer is, of course, yes. Next step, please. Next slide, sorry. Now, here is the schematic reflection of what I've been talking about. And can we briefly, for 20 seconds, go to the next slide? This is what it is now. And the next slide is what it will be. You can see already in a graphic representation how much easier it will be. Okay, back to the previous slide, please. There you see the steps in a half circle, starting from the top left-hand corner, moving to the right, crossing the line, that's the imaginary border between 2 countries, and then going to the recipient state. I'll deal with them briefly. First, the public document is signed in the state of origin. There is authenticating action, authentication, civil registry, for instance, in the state of origin, authentication by the Ministry of Justice, for instance. In the Netherlands, it happens to be the district court. The third one is the Ministry of the state of origin, the foreign ministry. Then the authentication of the state of production by the consulates. And finally, the authentication by the foreign ministry of the state of destination. So in the meantime, the document has reached, in our case, Indonesia. Again, this is the old system. And it moves back to the left-hand bottom corner, where the public document is ready to be produced or used in a state of destination. Next slide. This is the future. 4th of June of this year, this should be in place. The public document is executed in the state of origin, in our case, the Netherlands. The apostille is issued by the competent authority in the state of origin, in our case, the district court, and thereafter, straight away, no Ministry of Foreign Affairs, no Ministry of whatever, it can be used in the state of destination. Next slide. I have thought it would be useful to you to let you know and let you see what an apostille actually looks like. Now, you should realize that in most cases, this is a stamp, a rubber stamp, a rather large one. It is, ink is applied to it. And then there's some background noise. In each field that must be filled in, the appropriate information must be entered. You see 10 fields. I will go briefly through them all. 1, the country is the state of origin. It has been signed by the name of the person that signed the underlying public document. For instance, a notaris, a notary. Number 3, acting in the capacity of. In our case, if it was a notary, it would say notaris, because the word is the same in Dutch. Number 4, there's the signal, the seal of, and there you insert the name which has affixed the seal and stamp on the underlying public document. That would be, in our case, the district court. Number 5, at. That is the place where it's done. So in our case, Amsterdam or Rotterdam, if we chose that district court. 6 would be the date. 7 would be the practice among competent authorities is different here. It is the name of the person who signs on behalf of the competent authority. So in most cases, that would be the clerk of the district court in the Netherlands. Number 8 would be the number under which the apostille is registered in the court. And number 9 would be the court stamp. And number 10 would be the signature of the person who's drawn up the apostille, filled it in, and has issued it. Next slide. Now, I've also given you here the model request form. It's probably too small to read. But perhaps if you do a printout of my presentation, you can read it. I've just added it for purposes of being complete. Nothing shocking, nothing that needs to be explained. Next slide, please. Now, here's the actual thing. I told you that I need, as a foreign lawyer in Indonesia, I need a work permit. And I told you that the work permit will not be issued by the Ministry of Manpower before it has a recommendation. The recommendation in my case must be given by Paradi, the Lawyers Association. Paradi will not do that unless they have a statement of good conduct. And they want that statement from the president of the Bar Association, the Lawyers Association in the Netherlands, of which I am a member. You may be surprised, why does Theo Becker need to be a member of a bar association in the Netherlands? Because he practices in Indonesia. Well, that's a requirement of the authorities here. They want me to continue to hold my qualifications in the Netherlands, because otherwise they think I lose that knowledge, I lose that experience. And by the way, Holland, as well as Indonesia, apply a system of very strict continued legal education. So I just don't get it so easily. I have to do my courses. I have to do my intermediate exams. But anyway, I did that. And as a result, on the 16th of March of 2021, Mr. E.J. Henrichs, who happens to be the president of the Amsterdam Bar Association, has confirmed that Mr. Theodor Bakker has continued to be admitted and is entitled to practice law in the Netherlands, and that I am considered to be of good reputation and character. And there are no disciplinary proceedings pending against me from behavior amounting to professional or other misconduct. Okay, well, Mr. Henrichs issued that. He then, next slide, he then took that to a notaris, to a notary, in this case, Mr. Cornelia Hagendijk. She is a well-known notary in Amsterdam. And what does she certify? Not that Mr. Henrichs was right in declaring that I'm a dependable person, not that I haven't had any disciplinary action against me. The only thing that she declares is that the signature, look at the third paragraph, the signature appearing on the attached document is the true and genuine signature of Mr. Henrichs. And she adds to that the undersigned has only legalized the signature of the person and has not verified whether the above-mentioned person has understood the content or the legal effects of the attached documents. So this is a reflection of the very principal notion that an apostille doesn't say anything about the content of the document. It only refers to its execution. Next slide, please. Well, we're not there yet under the old system. We've seen that Mrs. Hagendijk has signed that notarization of the statement of good behavior of the president of the Bar Association. Now, Mrs. Hagendijk's signature under her own notarial statement must be authenticated. And that does the competent authority. Competent authority, as we know, is the district court in the Netherlands. So they signed it. I hid the signature just for privacy reasons. And the court attaches its seal. That's that round thing with the coat of arms of the Netherlands. That's not enough. We've been now at the district court. Then we need to go to the Minister of Law and Human Rights. No, wrong. Foreign Affairs. That's the one in the middle. That's been signed on behalf of the Ministry of Foreign Affairs by Mr. Snell, Mr. T.R.L. Snell. His signature is then taken to the Indonesian embassy in The Hague on the Tobias Asserlaan, and there it is authenticated by the Indonesian embassy. How does the Indonesian embassy, how can they do that? How do they know that that signature is correct? Because the Ministry of Foreign Affairs has given all the embassies in the Netherlands lists of names and signatures of persons who can make this declaration for their benefit. So it's an automatic system as long as it's still under the old regime before the e-apostille. It's just a question of checking manually. But as soon as the e-apostille is implemented, it'll be automatic in a split second. So I hope that this sequence of events shows you two things. First, how cumbersome and time-consuming the current system is, and how great it would be if we could do away with many of the steps that I've described here. And two events are coming. First of all, Indonesia will become an official party to the convention in June of this year. And hopefully, fast afterwards, we will all change the system by e-apostilles. Next slide, please. Now, let me see if I have. Oh yeah, I should, before we get to the possible grounds of rejection, I should ask you if you have any questions. Let's do a few more questions. I'll go to the chat room. And there we have.
We already have a very, around several new questions, Mr. Theo.
Sorry, I didn't hear you, Putri.
We already have several new questions here.
Yeah, I was just going to the questions. Shall I deal with the questions?
Yeah.
Okay, this is from Ketut.
Yes.
Parikasit. Sorry for my pronunciation.
You pronounce it correctly, sir.
Oh, nice. Thank you. I've been a few years here. I love it here. My second question, Indonesia has just joined the club recently. Will Indonesia acknowledge apostille issued by other countries in the past, or only since Indonesia joined? Gosh, what a difficult question. What a good question. I don't know. I don't know whether it will be given retroactive effect. I can think of arguments why it shouldn't, and I can think of arguments why it should. But I frankly don't know what the answer is. So I'm not going to answer that question. I'm sorry to disappoint you, but what I will do is note this question down and take it to my Indonesian colleagues to see if they have an answer. Can I ask you a favor? Can I ask you a favor to write me an email with this question? Otherwise I forget.
Okay, if you would let me know your email address.
I beg your
I can
pardon?
always ask them. Can I have your email address then, or can I get it from the moderator sometime?
Yeah, you can get it.
I will
You-
get from the moderator.
You can get it after the session.
Okay. If you don't mind, can you please scroll up? I have another question. My first question, you have time to answer that.
You're breaking up. I think you want your first question also to be dealt with.
Yes, please. It's an up there somewhere.
Oh yeah, got it.
It's a little bit screwed. Okay.
Got it. 1103. I have a case example. A British person has a civil lawsuit case in Indonesia and needs to hire a lawyer to represent him in Indonesia. The lawyer needs a power of attorney signed by both the British gentleman and the lawyer. Yeah. Both parties are currently in their respective country of residence, i.e. the British person is in the UK, as you say, the lawyer signed a document in Indonesia. Which country should the apostille issued for the power of attorney, which will be used in Indonesia? Well, I think that would be the United Kingdom, because you say that the person who gives the power of attorney is currently there. And mind you, you don't have to be a national of a certain country in order to get an apostille. You just have to be, you don't even have to be a resident, I don't think. But I don't know that. That depends on the British rules. The answer is the UK. In which country should the apostille be issued for the power of attorney? For the British person who gives the power of attorney, it should be the UK. So they would follow the apostille rules in the UK. What does that require? You need to find out, the UK person or his lawyer needs to find out who is the competent authority in the UK. Is that the Ministry of Law there? Is it a district court? And he would simply follow much of the procedure that I've outlined. He would first sign the power of attorney, take that to the notary, have the notary's signature either authenticated through the long route. If the power of attorney would be issued today, it would be the long route with the 5 steps. If it's issued on the 10th of June, when the accession of Indonesia has become valid and binding and irrevocable, then it will be the short route, because both the UK, which I know is a member of the Apostille Convention, and Indonesia are both members. And remember, the first test is very simple. Are both countries a member? If one country is not a member, the Apostille Convention does not, in most cases, apply. Now let's move to the Indonesian lawyer. He will want to accept the power of attorney. Strictly, legally, it's not necessary, but the practice is that Indonesian lawyers always accept the powers of attorney given to them. And here you have the interesting thing, because that's a domestic document issued in Indonesia and used in Indonesia, it doesn't need an apostille. It may be that the court requires notarization, just to make sure that the acceptance of the lawyer was signed by the lawyer. But I'm not an Indonesian litigator, so I wouldn't know the answer to that. But I think you were basically interested in the UK position with your British citizen. And there I've confirmed that that would be subject to the UK procedures. Before the June, after the June, competent authority under the Apostille Treaty. Yeah? let's do two more questions. Here we go. Aryavan Surya Librata. I would like to ask a question. Indonesia is known as a maritime country, and a lot of trade from other countries is by the sea. Is maritime law included in the Apostille Convention? I'm glad you asked that question because it allows me to take away a misunderstanding which I've got lots of questions asked about. It is irrelevant what the type of law is that is being dealt with in the document that's being authenticated. So it could be maritime law, it could be criminal law, it could be contract law, it could be aviation law. Any type of law can be applicable to the document that is being apostilled. The person, the competent authority, is not interested in what the document deals with. The competent authority is only interested in the valid execution. It also doesn't make a difference whether the underlying document is governed by Dutch law, by Indonesian law, by UK law, by American law. All of that is irrelevant because it's got nothing to do with the author, with the signature, except, and that's why the question is still relevant, where the country of the law of the country of origin has specific execution requirements. Then the competent authority might, I'm not saying they will, but they might ask themselves whether that document conforms to the specific execution requirements that the law of the country of origin imposes. Is that clear? Have I made myself understood?
It's clear, sir. Thank you very much. Clear.
Good. Let's go on to the text then. And I'm just looking at the time. We are 20 minutes after the hour, so I think I'll move a bit quicker. I still got a few pages to do. I thought it would be useful for you to know whether an authority can reject apostilles. The answer is yes, but only for limited reasons. The convention, one of those reasons you can ask yourself is if, well, first of all, what I say there is true. The convention does not specify any grounds on which a contracting state may reject an apostille, in the sense that its effect may be refused. And in view of the purpose of the convention to facilitate the use of public documents, apostilles should be routinely accepted unless there are serious defects. And I will list a few defects that there are thinkable. First, the apostille document is expressly excluded from the scope of application. That's pretty obvious. If it's not a public document, you can't put an apostille on it. Next slide, please. Another obvious one, the issuing state is not a party to the convention. You can't invoke the apostille treaty. Third, the apostillized document is not a public document. We dealt with that. It must be public. Fourth, the apostille is not issued by the competent authority. Very essential. If you come with a Dutch document that has an apostille from the Ministry of Foreign Affairs, it's not valid. It must be done by the district court because that is the competent authority in the Netherlands. Next slide, please. Next one, apostille is issued for a public document for which the competent authority is not competent to issue apostilles. there it may be rejected if it was issued by an authority that wasn't competent. And that information can be easily obtained from the apostille section of the court. And in case of doubt, the recipient should contact the competent authority itself. The 10 numbered standard information items that we dealt with on the form, if they haven't been all completed, filled in, or be deemed not applicable, and then it usually mentions the letters NA for a non-applicable, or if it was, yeah, non-applicable, then the apostille may be refused here in Indonesia. Next, the apostille was detached from the document. Then it may be rejected, and the competent authority should advise users wishing to make photocopies to avoid detaching the apostille, because that has a risk that one becomes permanently detached. Well, the 8th one is pretty straightforward. If it's forged or altered in a way, for instance, by crossing out names and replacing them by other names, that all invalidates the apostille. Also, because it doesn't correspond to the information that's recorded in the register. Next. I also think it would be useful to see which grounds may not be used. The law of the state of origin determines the public nature of the underlying document. So if the law of the state of origin says that it's a public document, that is a judgment that is irrevocable, that can't be rejected. Next. So the law of the state of origin is paramount. Yeah, next. We're nearly there, guys. Minor form defects are not important. You can't use that as a reason as Indonesian authority to refuse it. And mind you, this is important if you are the person who wishes to know whether you can rely on the apostille. Because you're doing business with somebody far away, you don't know him, you don't know whether he's alive, you don't know whether he's... You want to know that the apostille was validly placed on that document. Now, these are some of the arguments that you can't use if you want to reject it. Next. An apostille may not be rejected on grounds alone that it contains additional text. An apostille may not be rejected because it's an e-apostille. E-apostilles are now part of the Apostille Convention. But if domestic law doesn't recognize e-apostilles, then the state of destination does not recognize electronic signatures. It shouldn't be used. Wet signatures on a paper form should be used in that case. But we all hope that that period will be soon over, because the whole world is going electronic, and so will the Apostille Convention. And interestingly, we should. I'm very interested to see how Indonesia will deal with that, because the law on electronic transactions in Indonesia is actually a very nice piece of legislation, and it's brief and it's concise, but it has all the elements in it So I think Indonesia is ready for it, except that it needs implementing regulations. Next, please. The methods of attachment of the underlying documents are not relevant. If it's different from that used by the competent authority, that is not a good ground to reject. It may also not be rejected because it has been drawn up in a language other than the language of the state of designation. If it has the language on the state of origin, then that's fine. And for instance, you can't refuse an apostille document because it's not in Bahasa Indonesia. That is not a relevant excuse. If it is English, it must be accepted. Now, this raises, by the way, and it's only now that I think about it, an interesting discussion, and I wonder if you have any views on that. What about the language law? What about that famous language law, which requires each document, no, each agreement to be both in Bahasa and in English? Does the Apostille Convention detract from that? Does it rule over that requirement? I don't know the answer, but it's an interesting discussion. Next slide, please. Apostille is not legalized or otherwise fully certified. Well, apostilles themselves don't need to be certified. And the convention provides that the apostille is the only formality that may be required. And therefore, you can't say, well, I don't believe that this is a valid apostille because it doesn't mean apostille. That would bring you into an endless formality. Okay, next, please. That's it. I think, let me see if I have any final remarks on my handwritten notes. Well, I have a note on the e-apostille, but I have said so much on that already that I think we can better use the time. And it's exactly 11:30 here in Bali to do some more questions because I enjoyed your questions. I think they're very good. I'm happy to go on, but I need to catch a flight this afternoon, so I need to stop strictly at 10 to 12. Can I give it back to the moderator?
Yes, sure, Mr. Theo. For the question and answer, we already have that several questions already during the presentations, and we still miss 2 questions here from Desa Cynthia. Maybe we will have a direct question and answer rather than on the chat box. So do we have Desa Cynthia here? You can ask your questions directly to Mr. Theo.
Hi, Desa.
Yes, thank you for the time. Good morning, Mr. Baker. My name is Cynthia. My question is, what are usually be the reasons why other countries object to a country's accession to the Apostille Convention?
What a good question. I don't know the answer. The reasons of objections, let me check the convention. I have it here in front of me. It's article. Well, there's 2 ways in which you can join the convention. Either you should have done it when it was still open for signing, but a country can also join later. And that is by a process called accession. It's dealt with in Article 12 of the Convention. And Article 12 in subsection 2 says that the accession shall have effect only as regards the relations between the acceding states and those contracting states which have not raised an objection to its accession in the 6 months after the receipt of the notification. Any such objection shall be notified to the Ministry of Foreign Affairs of the Netherlands. It doesn't give any reasons. So I'm afraid that I don't know the answer to your question, Cynthia. But again, as I said with one of the previous persons who did a question, I'm so interested myself that I'm going to check it out for you. And if you send me an email through the Secretariat, I will give you an answer.
Okay, thank you, Mr. Baker.
You're welcome.
Okay, thank you, Cynthia. Well, next, Mr. Theo, we have questions from the lecturer. Here we have Ibu Fani.
Okay. Yes. Hello, Mr. Baker. Theo Baker.
Hi.
I'm Fanny, one of lecturer of Faculty of Law, Ngurah Rai University. I have a short questions about apostille. As we know that there are different stage procedure and acceleration of the legalization process in each country. So what if the document in a state of origin is include public documents, but it is not include document public in the states of destination, it will be rejected for upload apostille or not? Thank you.
Good question, relevant question. And luckily, I now have a question that I can answer. It's irrelevant. The state of destination has got nothing to say over the qualification as a public document in the state of origin. It's the state of origin that determines whether a document is a public document and therefore subject to treatment under the Apostille Convention. I don't have to spend any more words on it. It's pretty straightforward.
Okay, thank you, Mr.
Thank you so much, Ibu Fani. Well, Mr. Theo, that's the closing for questions and answer sessions, since we already almost reaching the time. So we don't want you to miss your flight as well. So I will close the sessions here today. And thank you so much, Mr. Theo, for giving us such an insightful presentations, and for all the participants who has participated here during the presentations for your very interesting questions. And to those who are not yet get an answer from Mr. Theo, he said that you can directly send the questions again to his email, so he can later on answer that whenever he's ready with the answers. All right, without reduce my respect, I will give the time back to the Master of Ceremony. Thank you.
Well, thank you so much to Ms. Putri Anggita, and also our speaker today, Mr. Theodore Baker, and of course all the participants. And the next agenda is award certificate presentation to Mr. Theodore Baker from Faculty of Law, Ngurah Rai University by virtual. Okay, Mr. Theo, I will take a picture. Thank you. Thank you, Mr. Theo. Next to Ms. Putri Anggita as a moderator today. Miss Anggita, I will take a picture. Thank you. Well, again, thank you so much for your time and knowledge that you shared today to us, Mr. Theo.
You're very welcome. It really was a pleasure for me doing this.
Well, ladies and gentlemen, now we come to the end of this event. I would like to say thank you so much for your kind attention, and I hope this event can provide new experience and knowledge for all of us. And let me end this Stadium General with Paramasanti. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, salam sejahtera untuk kita semua. Salam sehat selalu. Thank you again, Mr. Theo.
Kayak teman masih suara.
Teman sebenarnya. Ini dekan.
Anggi,
Bahasa Inggris.
Rektor.
everyone. Bu Anggi, sorry. With Mr. Theo.
Mr. Theo. Hello.
Yeah.
Hello, Mr.
Yeah.
Theo. Yes. Before you leave, can we take a picture before with all of audience?
Yes. What a good idea.
Okay, Mr. Theo. Thank you. Wait. Okay. First stage. 1, 2, 3. Next stage. Next stage. Next stage. Sorry, Mr. Theo, we have 14 stage.
Okay, next page.
Okay, because okay, Mr. Theo, thank you for your time and knowledge to us today.
You're very welcome. It was a pleasure. Let's do this again, shall we?
Yes, and let's do
Sure,
this
Mr. Theo.
again. And you come to our university. So once again, on behalf of Universitas Ngurah Rai, I say thank you very much, Mr. Theo Becker, my dear friends. I hope that we can see either in Bali or in Jakarta very soon. And let's the COVID go away from us very soon. So once again, thank you very much.
Yeah.
We love it, and then we appreciate and very, very interesting topic. Thank you.
Well, I hope you enjoyed my presentation.
Sure.
Yeah, sure, of course, Mr. Theo.
Thank you everyone too.
Thank you so much, Ibu,
Thank
for
you
the
Pak
chance.
Dekan, Wakil Dekan,
Terima
Kaprodi,
kasih.
semua
Terima kasih, Bu
jajaran
Rektor.
MC, Ibu moderator, dan semuanya,
Oke,
Ibu
terima
Jenny
kasih.
juga, ya, the team committee, semuanya luar biasa hari ini. Terima kasih banyak. Ya, kita akan lakukan lagi di lain kesempatan. Oke, terima kasih.
Terima kasih, Bu Rektor.
Terima kasih.
Semuanya. Terima kasih,
Bu
Mr.
Rektor.
Theo.
Thank you.
Thank you.
Thank you. Terima
See you
kasih.
next time and goodbye.
Thank you.
Andika Bagaskara, Bu. Hukum A2.
Bagaskoro,
Thank you.
Bagaskoro, thank you.
Thank you. Siap. Thank you semua kan.
Thank you.
Untuk teman-teman yang butuh informasi akademik, bisa hubungi kakak yang cantik ini ya.
Halo, bisa dibantu?
Fakultas
Andika
Hukum
Bagaskara,
juga
Bu.
memiliki ruangan
A2.
peradilan semu.
Sidang dibuka dan terbuka untuk umum.
Yuk kita lihat ruang perkuliahannya. Selain perkuliahan tatap muka, Fakultas Hukum juga melaksanakan perkuliahan online. Untuk mencari referensi, saya selalu datang ke perpustakaan ini. Universitas Ngurah Rai juga menyediakan program beasiswa dan untuk info lebih lanjut bisa kalian cek di website Universitas Ngurah Rai. Selamat datang di Fakultas Hukum Universitas Ngurah Rai. Yuk kita lihat fasilitasnya.
Untuk teman-teman yang butuh informasi akademik, bisa hubungi kakak yang cantik ini ya.
Halo, bisa dibantu?
Fakultas Hukum juga memiliki ruangan peradilan semu.
Sidang dibuka dan terbuka untuk umum.
Yuk kita lihat ruang perkuliahannya. Selain perkuliahan tatap muka, Fakultas Hukum juga melaksanakan perkuliahan online. Untuk mencari referensi, saya selalu datang ke perpustakaan ini. Universitas Ngurah Rai juga menyediakan program beasiswa dan untuk info lebih lanjut bisa kalian cek di website Universitas Ngurah Rai.
Selamat